Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to the Aitken Robertson YouTube channel. I'm Melanie van Orde, your paralegal host, and joined today by Counsel Dan Lemaire. Today's topic is Section 278 applications in sexual assault cases. We will explore how the Section 278 of the Criminal Code govern the procedures for the production of personal records concerning the complainant in sexual offense cases. So join us as we delve into the specifics of these applications and their role in the criminal defense. Hi, Dan.
Hi, Melanie.
How are you doing?
I'm well. How are you?
I'm doing fine, thank you. Dan, what are Section 278 applications?
So in a sexual assault case, if you're facing that sort of charge, there are some other sexual-based charges that this applies to as well. If you wish to adduce any sort of record at the trial, specifically to cross-examine the complainant, such as a diary entry, a text message, things of that nature, then you need to bring an application in advance. That only applies where the complainant has a reasonable expectation of privacy. And so things like medical records, a child welfare record, adoption records, journals, things of that nature are classic examples. But text messages, Facebook messages, things like that could also apply as well. And so it's very important that you bring those things to your lawyer's attention very early on in your matter if you intend to use them at trial.
And then what are some grounds for requesting the production of a record under Section 278 applications?
So if the record is not in your possession, but you are aware that it exists, you can bring a separate application for production of that record, either if it is in the Crown's possession or if it may be even in the possession of a third party, such as a doctor or a counselor. In that situation, you are placed in a bit of a disadvantage because you need to articulate a reason why you require that record, even though you haven't actually seen it yet. A classic example would be if you have grounds to think that a counseling process or a medical process has perhaps influenced the complainant's decision to go to police or influenced his or her perception of events. In that case, the record may be of assistance to the court in determining the reliability and credibility of the complainant's version of events.
And then what are some of the factors that a judge considers when determining whether to order production of the record?
So primarily what the judge's task is to balance your right as the accused person to make full answer in defense while also taking into account the usually high expectation of privacy that complainants have in things like medical or counseling records. Obviously, that is a relationship that is a very private one and usually has confidentiality. And so a judge is not going to lightly produce that record to the defense unless there is grounds to do so.
And you did mention that these applications are separate applications, but when do they typically take place in the legal process?
They can be brought at any time during the process, before trial or even during trial, but the best practice is that defense counsel and the accused person, the client, have a thorough conversation early on about what records might exist, what records are in the possession of the Crown, what records are in the possession of the client, And that really should be happening early on so that the application can be brought pre-trial to minimize delay and expense.
Well, thank you so much for all the information today, Dan. And thank you for everyone else for joining us today on the Legally Speaking Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website, or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.